Is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired? That is a misdemeanor. It is punishable by up to 93 days in jail, up to $300 fine plus court costs. The court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services, order any rehabilitative services or community service the court deems necessary. You understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
Yes?
Yes.
All right. You signed an advice of rights form today?
Yes.
Any question regarding any of those rights? Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No.
Are you on parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense? August 7, 2023, at the location of US 23 near Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consumed intoxicating liquor?
Yes.
What did you have and how much?
I don't.
You don't remember?
How much alcohol?
Okay, how much? What did you have?
Tequila.
Tequila? Were you stopped by the police or was there an accident?
An accident.
What happened?
The car rolled over.
Pardon?
The
You
car.
need to speak up, young lady.
The car rolled over on the freeway.
All right. That didn't spontaneously happen. What did you do?
I lost control of the vehicle.
And you rolled it.
Yes.
Did the police and paramedics arrive?
Yes.
Were you taken to the hospital?
Yes.
Were you given a blood test?
Yes.
What were the results?
That I don't.
Was it 0.84?
The defense would stipulate to 0.84, Your Honor.
Do you have any reason to dispute those blood test results?
Me? No.
Yes. No? Go ahead. Do you have any reason to dispute at all those blood test results?
Oh, yes, I do agree.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defense?
This is the no turning back moment. By pleading guilty, Angel Wilson gives up her right to a trial, an appeal, and any chance to challenge the evidence later. The judge is carefully locking everything in. This is courtroom procedure at its most serious. No drama yet, but it's coming.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 10th at 9 a.m.
July 10th, 2024, 9 a.m. I have another bond resolution.
Yes, Your Honor, and I have discussed that with Ms. Wilson. She does, and I have then reached out to Community Corrections and then got the actual scram report from that company. I did discuss it with Ms. Wilson. She does dispute.
This is where the tone shifts. Not a traffic stop, a rollover crash on the freeway. The judge immediately zeroes in because accidents like this don't just happen. This is no longer about paperwork. It's about public safety.
both drinking and a tamper. She did provide me proof that she was at work as CNA during that time. Further, both in the bond violation report I received from Scram, as well as my client confirmed, she received a new Scram tether on May 28th due to it was either a software update or some sort of malfunction. She had 0 violations for the entire month of May. She got a new tether on May 28th. And then on May 31st, there was an alleged tamper that started at, I believe it was 7:10 a.m. in the morning and stopped at 10:29 at night. During that time, my client was at work from 6:54 a.m. to 3 p.m. She denies drinking whatsoever.
What time did the accident happen?
I'm sorry?
The offense, what time was she at work there at that point too?
No, Your Honor. It was at 4:20 a.m. was when law enforcement arrived on scene.
So early morning doesn't really matter, does it, counsel?
She was at work, Your Honor, and did provide me a screenshot that she clocked into work at 6:54 a.m.
And so, go ahead, I'll let you go.
We would be requesting a formal hearing as to the bond violation. If the
Okay,
court
she'll
is-
get her hearing, but she's gonna be remanded pending that. I mean,